name is Naomi, my beautiful people. I'm going to take you through a feature whereby it analyzes the tension between privacy rights and the public's right to information. This feature has dealt on the reference on Campbell v. MGN in 2004 in the United Kingdom. The Naomi Campbell case represents a turning point in the legal understanding of privacy, particularly in relation to media intrusion and the treatment of publics. Between the headlines and the human, where privacy meets the public's rights to know. In the digital age, where breaking news travels faster than ever, and every smartphone is a camera, the boundary between what should be public and what should remain private is increasingly contested. Central to this tension is the uneasy balance between the media role in informing the public and the individual right to a private life, a boundary tested again and again in courts, newsrooms, and society at large. One of the most influential legal battles in the United Kingdom that crystallized this conflict was Campbell in 2004, a Supreme Court, then House of Lords, decision involving supermodel Naomi Campbell and the Daily Mirror. The newspaper published photographs of Campbell leaving a narcotics anonymous clinic where she was undergoing treatment for drug addiction, contradicting earlier public denials about ever taking drugs. Campbell argued that while the story itself might be newsworthy, the publication of intimate details and photographs was an unjustified invasion of her privacy. In a close 3-2 judgment, the court ruled in her favor, holding that the media's inclusion of detailed information and photographs overstepped the mark. The treatment could be reported as part of setting the images taken outside a confidential support meeting where private medical information not justified by the public interest. The decision did more than decide one lawsuit. It helped shape the modern thought known as misuse of private information in UK law, a doctrine distinguishing between legitimately disclosable facts and private data that individuals are entitled to keep out of public view. When press freedom and privacy collide, for journalists and editors, the Campbell case exposed a deep ethical dilemma. When is it right to publish a story that intrudes into someone's life? Many in the press feared that the ruling would create a backdoor privacy law that stifles important reporting. Critics argued that if you cannot show the evidence, especially photographs, the truth of a story becomes harder to convey. Yet defenders of privacy rights countered that personal health, family life, and confidential treatment are precisely the kinds of sensitive information that should not be fodder for sensational headlines, even if the subject is a celebrity. The court's decision underscored that public figures do not forfeit their right to privacy simply by being famous. The court's approach essentially required a balancing act, weighing Article 8 of the European Convention on Human Rights, the right to private and family life, against Article 10, freedom of expression, only where intrusion could be justified by a real and overriding public interest should privacy yield. This feature has brought to show that real-life privacy breaches beyond Campbell. Campbell's case wasn't an isolated flashpoint. Across the globe, media organizations have faced criticism for publishing stories that, while newsworthy, ventured into exploitative territory. Phone hacking scandals such as those involving News of the World in the UK reveal journalists intercepting voicemail messages of celebrities and crime victims alike, a breach of both legal and ethical standards that eventually helped close the tabloid. Unconsented publication of personal data, like the release of private medical information about public figures during health crises, has promoted backlash and legal complaints, forcing news outlets to rethink reporting practices. Publishing images of victims or minors, even when tangential to a news event, often triggers public outcry and regulatory scrutiny driven by concerns about harm and dignity. Each instance forces the same core questions. Is there joining societal value in publishing this? Is the intuition necessary to understand the story? And importantly, could less intrusive means convey the truth? The Naomi Campbell case has brought ethical dilemmas in the newsroom, where journalists do more than chase headlines. They steward public knowledge, yet newsroom decisions are often shaped by commercial pressures and competitive urgency, pressure that can push ethical boundaries. Editors wrestle with questions like, does the audience really need to see this image, or is the textual fact sufficient? Is the subject's behavior genuinely relevant to public interest or merely salacious? Are we respecting dignity and autonomy, especially for non-public figures? These dilemmas are not academic. Ethical journalism codes like from the Society of Professional Journalists or the Press Complainants Commission in the United Kingdom emphasize minimizing harm and respecting privacy unless there is a clear and justifiable public benefit to disclosure. Naomi Campbell case has brought legal consequences and the road ahead, whereby in headlines there are legal stakes. Campbell's case awarded relatively modest damages to her, about 3,500 euros, but also required the newspaper to cover her legal costs, which in some contexts can reach to six figures when including success fees under United Kingdom conditional fee agreements. Critics have argued that such costs can shield press freedom by making litigation financially perilous for media outlets. Yet courts have reinforced that privacy protection serve the public too by safeguarding trust, human dignity, and the integrity of personal life. Legal frameworks, including data protection laws and human rights instruments, increasingly reflect a global trend toward recognizing privacy as fundamental right, not a luxury. Naomi Campbell case has brought a constant negotiation where the tension between privacy rights and the public rights information is not a binary choice but a constant negotiation between transparency and dignity, accountability and autonomy. Cases like Campbell in 2004 remind us that even in a world of 24/7 news cycles and intrusive technology, the law and ethical practice strive to ensure that news serves society without trampling the most intimate aspects of individual lives. In the end, privacy and public interest are not opposing forces but parameters within which a democratic press must operate responsibly, thoughtfully, and with respect for the humanity behind every story.